Disparate Treatment and Disparate Impact, Title VII of the Civil Rights Act. Protected Classes. Bfo Cues. Questions and Answers. 4. PHR, SPHR, SHRM-CP, and SHRM-SCP.
Have you subscribed to this channel? Please do. Would you like to see more videos like this for free? Then please subscribe and click on the like button.
Title VII of the Civil Rights Act of 1964 prohibits employment discrimination against protected classes which are race, color, religion, sex and national origin. Title VII established the basis for two types of unlawful employment practices, disparate treatment and disparate impact. Title VII applies to employers with 15 or more employees. Exceptions to Title VII include bona fide occupational qualifications, Bfo Cues. Religious organizations may give preference to members of their religion, and Indian reservations may give preference to Native Americans living on or near the reservation. Merit systems, seniority systems, and piece rate systems are allowed under Title VII if the systems are not the result of an intention to discriminate against protected classes. Title VII ensures that employment outcomes are based on objective and job-related criteria. Disparate treatment is deliberate employment discrimination. It refers to unequal behavior or less favorable treatment towards an applicant/employee who is a member of a protected class. Disparate treatment is unlawfully and intentionally treating an individual differently in the employment context. Remember, disparate treatment is outright and intentional discrimination against a member of a protected class. Examples of disparate treatment: applying different skill tests or pay rules for men and women, giving a skill-based employment test to only minority candidates, requiring only women to take a safety test for a security job. Members of a religion are screened out of a selection process because the religion requires frequent prayer breaks. Security guards search employees of a certain color while employees of another color are not subject to security searches.
Have you subscribed to this channel? Please do. Would you like to see more videos like this for free? Then please subscribe and click on the like button.
Disparate impact is unintentional employment discrimination. It appears to be fair at face value, but it is discriminatory in application. Disparate impact takes place when employment processes which appear impartial, unbiased and fair, inadvertently result in discrimination in practice and outcome against members of a protected class. Disparate impact is concerned about the outcome, not the intent, of an employment process which appears on its face to be neutral, but results in discrimination when implemented. Disparate impact occurs when a seemingly neutral employment process that is not job-related discriminates against a protected class when applied. Examples of disparate impact: a job description states that all applicants must be at least 6 feet tall, and the average height for a female is 5 feet 4 inches. All applicants take a test, but majority of the questions are derived from knowledge of cultural areas that minority applicants are less likely to possess. All applicants are tested, but only members of a specific religion are eliminated based on the results of the test. A company requires a high school diploma for a job where the job can be performed without the diploma, and members of a specific race are disproportionately screened out because of the requirement. Protected classes are people groups who share common characteristics and are protected from employment discrimination by law. Protected classes include race, religion, color, sex, national origin, people over 40, people with disabilities, veterans, pregnancy, genetic information, etc. For Title VII, there are 5 protected classes: race, color, sex, religion, and national origin. This means employers cannot discriminate against individuals based on these 5 protected classes.
Have you subscribed to this channel? Please do. Would you like to see more videos like this for free? Then please subscribe and click on the like button.
Bona fide occupational qualification, Bfo Cues, simply means it is legal, in certain instances, to discriminate on the basis of religion, sex, and national origin because a related attribute is necessary to normal business operations. Bfo Cues is a feature that employers can consider when making employment decisions which in other contexts would constitute discrimination and be in violation of Title VII. An employer may defend the use of a Bfo Cues that screens out an individual based on sex, religion, national origin by showing that the Bfo Cues is job-related and consistent with business necessity. Note that while religion, sex, or national origin may be considered a Bfo Cues, Race and color cannot be Bfo Cues. Examples of Bfo Cues: hiring Catholic professors to teach Catholic theology at a Catholic school. A male maximum security prison requires guards to be male. Restroom attendants for a female restroom must be female, as restroom users have privacy rights. A women's clothing website can hire only female models to wear women's clothes. A manufacturer of men's clothing may lawfully advertise for male models only. A religious school may lawfully require that members of its faculty be members of that religion, and may lawfully refuse employment to an applicant who is not a member. Question: the Griggs vs. Duke Power case established the judicial concept of a. adverse classes, b. adverse treatment, c. disparate impact, d. disparate treatment. The answer is C. The Griggs vs. Duke Power court case established the judicial concept of disparate impact. Disparate impact occurs when people of a protected class are being disproportionately excluded from employment as a result of using seemingly neutral practices. Question: the McDonnell-Douglas Corporation vs. Green case established the criteria for a. adverse impact, b. employer unfair labor practices, c. reverse discrimination, d. disparate treatment. The answer is D. Disparate treatment is unlawful and intentional discrimination. An individual can establish a prima facie case of disparate treatment if the individual can prove that he belongs to a minority group, applied and was qualified for a job for which the employer was actively seeking applicants, was rejected, and was rejected while the same position with the same qualifications remained open afterwards. Prima facie means based on first impression, or accepted as correct until proven otherwise.
Have you subscribed to this channel? Please do. Would you like to see more videos like this for free? Then please subscribe and click on the like button.
Which of the following is an example of disparate treatment? A. All production workers are subject to stricter attendance requirements. B. Asians are subject to stricter disciplinary procedures. C. A skill-based test with cultural nuances results in lower pass rates amongst minorities. D. Height requirements are set for all firefighters. The answer is B. Disparate treatment occurs when employees who are members of a protected class, in this case, Asians, are treated differently from other employees. Option C and D are examples of disparate impact. Question: the Equal Employment Opportunity Commission established Title VII of the Civil Rights Act of 1964. A. True. B. False. The correct answer is B. On the contrary, Title VII of the Civil Rights Act created the Equal Employment Opportunity Commission, EEOC, as an enforcement agency for its provisions. Question: which of the following statements is true of a bona fide occupational qualification? A. It does not justify the use of legitimate practices to treat members of different groups differently. B. It justifies discrimination against applicants based on customer preference and client privilege. C. It permits an employer to discriminate against applicants based on sex for business necessities. D. It can be used by employers to discriminate against applicants based on color. The answer is C. Employers can discriminate based on sex, religion, and national origin where the attribute is job-related, and of business necessity.
Have you subscribed to this channel? Please do. Would you like to see more videos like this for free? Then please subscribe and click on the like button.
Question: which of the following is a similarity between the Equal Employment Opportunity Commission, EEOC, and the Office of Federal Contract Compliance Procedures, Ofccp? A. Both agencies are solely responsible for developing the uniform guidelines on employee selection procedures. B. Both are the primary regulatory agencies for enforcing equal employment legislation. C. Both have the power to enforce the provisions of the Civil Rights Act of 1991. D. Both were created by the Department of Labor. The answer is B. Both the EEOC and the Ofccp are the primary enforcement agencies for equal employment legislation. Question: Exists when individuals in similar situations are regarded differently based on their race, color, religion, sex, and national origin. A. Disparate impact discrimination. B. Retaliation. C. Disparate treatment discrimination. D. Reverse discrimination. The answer is C. Treating employees differently because of their race, color, religion, sex, or national origin is disparate treatment. Disparate impact occurs when a neutral practice results in unintentional discrimination for a protected group.
Have you subscribed to this channel? Please do. Would you like to see more videos like this for free? Then please subscribe and click on the like button.
Discrimination against members of a majority group is associated with what type of discrimination? A. Adverse impact. B. Affirmative action. C. Reverse discrimination. D. Disparate treatment. The answer is C. Reverse discrimination holds that giving preference to minorities discriminates against members of the majority group. Question. Which of the following is true about Title VII of the Civil Rights Act of 1964? A. It permits employers to hire applicants belonging exclusively to a specific nationality. B. It protects veterans against discrimination. C. It ensures no retaliation for employees whose employers inadvertently obtain their genetic information. D. It permits pay discrimination based on job performance. The answer is D. Title VII permits pay discrimination based on merit, such as job performance. Other systems allowed under Title VII include seniority systems, piece rate systems, and bona fide occupational qualifications, Bfo Cues. Question. Bona fide occupational qualifications, BFOQ, can be used in disparate treatment cases involving race and color. A. True. B. False. The answer is B. Race and color cannot be Bfo Cues.
Have you subscribed to this channel? Please do. Would you like to see more videos like this for free? Then please subscribe and click on the like button.
Question. If NECA's supervisor subjects her to a more severe discipline for an act of misconduct that a fellow employee not in her protected group was pardoned for, the employer may face charges of A. Adverse impact. B. Disparate treatment. C. Disparate impact. D. Retaliation. The answer is B. NECA experienced disparate treatment from her supervisor. Disparate treatment is intentional discrimination against individuals of a protected class. Which of the following is a valid Bfo Cue? A. A woman was not hired for a construction project because turnover rates among women is higher than men in the construction industry. B. A woman was not hired for a sales position because women are less capable of aggressive salesmanship. C. A woman was not considered for the role of Abraham Lincoln in a movie. D. A man was not hired for the role of an airline attendant based on employer requirements. The answer is C. Bfo Cue can apply in terms of sex when a movie company requires that only men can play the role of a male character such as Abraham Lincoln. Title VII of the Civil Rights Act 1964 prohibits discrimination based on all of the following protected classes except A. Race. B. Religion. C. Retaliation. D. Color. The answer is C. The 5 protected classes established by Title VII of the Civil Rights Act of 1964 are race, sex, color, religion, and national origin. Participating in a complaint process is a protected activity, that is, protected from retaliation.
Have you subscribed to this channel? Please do. Would you like to see more videos like this for free? Then please subscribe and click on the like button.
In which of the following jobs would gender most likely be appropriate to use as a Bfo Cue? A. Prison staff at federal prisons. B. Teacher at a private all-girls school. C. Firefighter in a state-owned department. D. Actor in a detergent commercial. The answer is B. A teacher at a private all-girls school may be required to be female. Per Bfo Cue requirements, airlines may exclude male flight attendants based on passenger preferences. A. False. B. True. The answer is A. A Bfo Cue defense is not valid based on passenger preference. Customer preference cannot be the basis of a bona fide occupational qualification, Bfo Cue. Question. Per Bfo Cue requirements, a woman can be excluded from working as a restroom attendant in a male restroom. A. False. B. True. The answer is B. Bfo Cue defense is valid for customer safety, workplace safety, and a reasonable expectation of privacy.
Have you subscribed to this channel? Please do. Would you like to see more videos like this for free? Then please subscribe and click on the like button.
Question. There are only 5 protected classes: race, color, religion, sex, and national origin. A. True. B. False. The answer is B. Protected class is a people group protected from employment discrimination. Title VII established 5 protected classes, but there are several laws that increase the number of protected classes. Question. How many days after a discriminatory incident is a person generally required to file a complaint with the EEOC? A. 30 days. B. 300 days. C. 180 days. D. 90 days. The answer is C. In general, you need to file a charge within 180 calendar days from the day a discrimination took place. The 180 calendar day filing deadline is extended to 300 calendar days if a state or local agency enforces a law that prohibits employment discrimination on the same basis. Question. Dash occurs when an officially neutral employment practice disproportionately excludes the members of a protected group. A. Disparate treatment. B. Unintentional exclusionary requirements. C. Disparate impact. D. Disparate treatment. The answer is C. Disparate impact is generally considered unintentional discrimination.
Have you subscribed to this channel? Please do. Would you like to see more videos like this for free? Then please subscribe and click on the like button.
Question. Dash exists when a particular practice is necessary for the safe and efficient operation of the business, and there is a specific business purpose for applying a particular standard that may in fact be discriminatory. A. Prima facie. B. Job requisition. C. Business necessity. D. Affirmative action. The answer is C. Business necessity is an employer's defense of an employment-related decision that is based on the requirements of the business, and is consistent with other employment decisions. Question. The fundamental duties of a position are known as A. Job functions. B. Essential job functions. C. Job analysis. D. Job descriptions. The answer is B. Essential job functions are the fundamental job tasks that any person in the position must be able to do. They are the reason that a job exists. Essential functions are the main job duties that an employee must be able to perform, with or without reasonable accommodation.
Have you subscribed to this channel? Please do. Would you like to see more videos like this for free? Then please subscribe and click on the like button.
Bona fide occupational qualifications, Bfo Cues, occur when is reasonably necessary to the normal operation of a business. A. Sex, religion, race. B. Religion, color, national origin. C. Religion, sex, national origin. D. Race, color, sex, religion, national origin. The answer is C. Race and color cannot be Bfo Cues. Religion, sex, and national origin can be Bfo Cues. Title VII initially prohibited discrimination against these protected classes except A. Disability. B. Veterans. C. Caregiver status. D. All of the above. The answer is D. The protected classes that Title VII prohibited discrimination against are these 5: race, color, sex, religion, and national origin. Question. Title VII of the Civil Rights Act currently applies to employers with how many employees? A. 25. B. 15. C. 50. D. It applies to virtually all employers. The answer is B. Title VII applies to employers with 15 or more employees, and to federal, state, and local governments.
Have you subscribed to this channel? Please do. Would you like to see more videos like this for free? Then please subscribe and click on the like button.
Question. An organization requires a high school diploma for a technician role. During a validity test of this employment requirement, it was decided that the job can be done proficiently by employees who do not have a diploma. The requirement will most likely result in A. Disparate treatment. B. Disparate impact. C. Poor reliability outcomes. D. Failure of selection guidelines. The answer is B. Disparate impact occurs when employment processes seem neutral but result in adverse impact on members of protected classes. It is unintentional discrimination against members of a protected class. And with that we come to the end of today's lesson. Check out the description box below for additional resources towards earning the PHR, SPHR, SHRM-CP, and SHRM-SCP. Facebook Practice Group. Class Marker PHR, SPHR, Practice Exams. Books on Amazon. Teachable PHR, SPHR online course. Remember to subscribe and like this video.